Pam Bondi just blew the lid off something that, until yesterday, most people assumed would stay buried forever. According to sworn court documents filed late Thursday afternoon, investigators are now looking at $127 million moving through 14 separate contracts in 3 different shell companies. Not rumors. Not anonymous leaks. Paper. Signatures. Banking confirmations. Evidence. I spent hours going through the material. The transcript alone runs more than 200 pages, and every page reads like another thread being pulled from a knot that suddenly refuses to stay tied. And here is the part the headlines barely touched. Pam Bondi was never an outsider to this story. She wasn't some analyst guessing from television studios. She wasn't a political opponent trying to score points. For months, she was inside the room. Former Florida Attorney General, then chosen as the president's nominee for Attorney General of the United States in late 2024, confirmed in early 2025. For a long stretch, she was the shield. Every investigation, every subpoena, every question directed toward the administration. Bondi stood between prosecutors and the people around the president. If the legal system was knocking on the door, she was the one answering it. But somewhere between January and last month, something shifted. The Southern District of New York began pulling at a set of financial threads: real estate transactions, foreign payments, corporate structures that, on paper, looked legal but didn't quite make sense when placed side by side. Investigators started asking questions about companies registered in Delaware, Nevada, and offshore jurisdictions. Then the timeline accelerated. A few weeks ago, federal investigators issued subpoenas to 3 holding companies incorporated in Delaware. Shortly after that, Bondi's personal attorney met with prosecutors twice behind closed doors. No cameras. No press statements. And then Thursday arrived. Courtroom 14B. Bondi walked in, took the witness stand, and everything changed. She was not there as a defendant. She was there as a cooperating witness. Her immunity agreement had already been signed on Monday. Now pause for a moment and think about that. A sitting Attorney General of the United States doesn't casually flip sides. That kind of move doesn't happen without pressure, calculation, and a mountain of risk behind it. When someone at that level decides to cooperate, it usually means 2 things. Prosecutors have something serious, and the witness believes silence would be even more dangerous. Inside that courtroom Thursday afternoon, Bondi handed prosecutors what they had been chasing for months: wire transfer records, signed agreements, time-stamped communications, emails, personal notes, and all of it entered into the record under oath. This was not speculation. This was testimony. According to the transcript, Bondi described 3 separate agreements executed between January and August of 2025. Each agreement involved payments routed through intermediary entities. In plain language, money moving through companies designed to obscure where the funds were actually going. The first filing, released Friday, contains a line that jumps off the page. It states that the witness confirmed direct knowledge of these agreements and observed payments being routed through intermediary corporate structures. What does that mean in the real world? It means Bondi says she watched the money move, and she knew where it landed. But the detail that really stopped me was buried deeper in the transcript. Page 89, paragraph 47. Bondi testified that she personally reviewed wire transfer confirmations totaling $18.2 million sent to a Nevada holding company, a company with no employees, no office, no obvious business activity. Curious, I checked the Nevada corporate registry. That company was created 6 days before the first payment arrived, and it was dissolved 11 days after the last payment cleared. Think about that timing. It's not messy bookkeeping. It's not amateur accounting. Structures like that usually exist for one purpose only: move the money, then disappear. And I remember reading that section twice because at first it felt too clean, too precise, almost like a script from a financial crime investigation textbook. But the documentation is there. Then came another piece. Page 112. Exhibit F. Bondi handed prosecutors 47 emails exchanged between herself and 3 members of the president's inner circle. All of them sent within a 2-week period last spring. The subject lines alone tell a story. One line read, "Restructuring arrangement." Another read, "Offshore structure urgent." Now step back for a second. The Attorney General of the United States exchanging emails, discussing offshore structures while holding office. That detail alone raises questions that lawyers and investigators are going to spend months unpacking. Reading through those emails, a pattern begins to emerge. Payments routed through Delaware LLCs with almost no public record. Contracts signed by intermediaries rather than principals. And whenever certain topics came up, communications shifted away from official channels and moved on to encrypted messaging platforms. Every message timestamped, every transfer documented. At this point in the transcript, you can almost feel the courtroom tightening. Because once documentation enters the conversation, arguments about memory and interpretation become much harder to make. And here's a thought that hits you while reading it. If Bondi truly saved these records while she was still inside the administration, then either she had extraordinary foresight or she believed one day she might need protection. Either possibility tells you something about the atmosphere inside those meetings. But the most explosive detail wasn't in the financial records. It appeared in the appendix. Page 147. Bondi described a meeting at Mar-a-Lago in February of 2025. 8 people present in the room. During that meeting, she testified that she was explicitly instructed not to document what was discussed. The instruction was clear. No notice. No records. Yet Bondi says she documented the conversation anyway. She kept handwritten notes at her residence and turned them over to prosecutors last month. And those notes referenced something far larger than a few wire transfers. A development project valued at $340 million involving a foreign sovereign wealth fund. According to the testimony, the deal was structured specifically to avoid review by the Committee on Foreign Investment in the United States. That committee normally evaluates foreign investments that could impact national security. Bondi's notes included a short phrase that prosecutors highlighted. They know the threshold. Stay under. If that line is accurate, it suggests the people designing the transaction understood exactly where the regulatory line was and intentionally structured the deal just below it. And this is the moment when the story stops feeling like routine political controversy and starts sounding like a complex financial investigation. Within hours of Bondi's testimony, 3 additional subpoenas were issued Friday afternoon. 2 went to former White House staff members. 1 went to a current member of the president's legal team. Meanwhile, the Nevada LLC mentioned earlier is now under federal investigation. Prosecutors have also requested banking records from 4 international financial institutions, including one based in the Cayman Islands. Those requests went out less than 72 hours after Bondi took the stand. That kind of speed tells you investigators were already preparing for this moment. And if you read between the lines, you begin to see the outline of something larger forming behind the scenes. Because prosecutors rarely move that fast, unless the testimony they just heard confirmed suspicions they had been building for months. At this stage, the public has only seen a fraction of the evidence. But even that fraction paints a picture of money flows, offshore structures, and decisions made behind closed doors at the highest levels of government. And when a cabinet-level official walks into a courtroom and starts connecting those dots under oath, you can almost hear the political earthquake beginning to rumble beneath Washington. Now let's slow down for a moment, because this is where the story becomes more complicated than a simple headline about betrayal or corruption. The documents Bondi delivered didn't just include accusations, they included evidence designed to stand on its own. Wire transfers, contracts, email chains, personal notes, all synchronized with banking timestamps. And that distinction matters. If this had been just a witness talking, defense attorneys would already be tearing it apart. Memory fades. Motives get questioned. Testimony becomes a battlefield of interpretation. But when a witness walks in with documentation that can be verified independently by banks, servers, and financial regulators, the conversation shifts. You can challenge a person. You cannot easily challenge a confirmed wire transfer. And that is exactly what seems to be happening here. One section of the filing outlines a payment trail moving through Delaware limited liability companies that exist almost entirely on paper. These entities had minimal operational records, no visible staff, and almost no public footprint. Yet, millions of dollars moved through them in a matter of weeks. The contracts tied to those transfers were signed not by the principals of the deals, but by intermediaries. Proxy signatures, temporary executives, individuals whose professional history appears to revolve around forming and dissolving corporate shells. Now, if you work in international finance, none of this is technically illegal on its own. Shell companies exist everywhere. Delaware and Nevada host thousands of them. Corporations use these structures every day for tax planning, joint ventures, and investment vehicles. But context changes everything. Because when those structures appear alongside encrypted communications, offshore accounts, and timing that lines up with government decisions, investigators start asking a different question. Not whether the structure is legal, but whether it was used to hide something. And that question is exactly where the courtroom began to tense up Thursday afternoon. Bondi described how communications around certain financial arrangements abruptly shifted away from official government channels. Instead of emails or documented briefings, participants began moving discussions to encrypted messaging platforms. That pattern alone doesn't prove wrongdoing, but it is something prosecutors pay very close attention to, because once communication disappears from official archives, accountability becomes much harder to trace. And that leads us to the emails. 47 messages exchanged within a narrow window last spring, several subject lines referencing offshore structures and restructuring agreements. Some messages referencing urgency. Now imagine being in that courtroom when those emails are introduced into evidence. Lawyers on both sides leaning forward, reporters scrambling to write down the wording, because every phrase suddenly becomes significant. And right here is where the defense begins pushing back. Trump's legal team moved quickly to frame Bondi's testimony as something very different from what prosecutors suggest. Their argument is direct and, in some ways, predictable. Bondi received immunity. That fact alone changes the incentive structure of her testimony. From the defense perspective, Bondi had every reason to give prosecutors something dramatic. Immunity deals are rarely handed out for free. A witness must provide value, something significant enough to justify letting them walk away from potential charges. So, the defense narrative began forming almost immediately. Bondi, they say, is not a neutral observer. She is a witness who negotiated for her own legal survival. That means every statement she makes now serves her interest. And if you're listening carefully, you realize something important here. Both sides actually have pieces of a valid argument. Because immunity deals do create pressure on witnesses to deliver useful information. Prosecutors expect cooperation that advances their case. That dynamic has existed in federal investigations for decades. But at the same time, prosecutors do not grant immunity blindly. They usually require documentation, corroboration, and independent evidence before making that decision. Which brings us back to the paper trail. Several legal analysts who are not aligned with either political camp have already pointed out that complexity alone does not prove criminal intent. A former federal judge now teaching law in Washington explained it bluntly during an interview Friday. Complex financial structures are not illegal by themselves. What prosecutors must prove is intent. Did the participants design the structure specifically to hide money, evade oversight, or mislead regulators? Or were these simply aggressive but legal financial arrangements? That question will eventually sit at the heart of the courtroom battle. And right now, nobody outside the investigation has the full answer. But here is the reaction you start hearing quietly among legal professionals reading the transcript. The documentation changes the equation. You can discredit a witness by attacking their credibility. You can argue that a cooperating witness exaggerated or misinterpreted conversations. Defense lawyers do that all the time. But when emails exist, when bank transfers exist, when handwritten notes align with those transfers, suddenly the story stops being just a story. It becomes something investigators can reconstruct piece by piece. And that is exactly what appears to be happening now. The political reaction, however, erupted almost instantly. Within hours of the testimony becoming public, conservative media outlets began framing the situation as a betrayal. Pam Bondi had long been seen as one of the most loyal defenders of the administration. She argued aggressively on television. She stood beside the president during multiple investigations. To many supporters, she wasn't just an official, she was family. So when word spread that she had taken the stand as a cooperating witness, the reaction was emotional. Some commentators called it treason against the movement. Others said it proved the pressure tactics of federal prosecutors. One former campaign official posted a message late Friday night saying she had been trusted like a member of the inner circle and that her decision was unforgivable. That sentiment matters because politics runs heavily on loyalty. And when someone who once defended you begins cooperating with investigators, supporters often see it as personal betrayal rather than legal strategy. But behind all the political noise, investigators appear focused on something much more mechanical. Documents, money flows, timelines. Those three elements form the backbone of nearly every major financial investigation. And according to the filings released so far, prosecutors now possess documentation that allows them to map out how funds move through a network of companies over several months. Another detail hidden inside the transcript hints at the pressure Bondi herself may have been facing. A year ago, the first cracks inside the administration reportedly began appearing. Bondi and members of the president's inner circle disagreed about how to respond to subpoenas from the Southern District of New York. Bondi reportedly advised compliance. Others pushed for delay. That disagreement may seem minor at first glance, but in legal strategy, the difference between cooperating and delaying can determine whether investigators gain access to documents quickly or spend months fighting in court. Over time, Bondi was gradually sidelined from certain meetings. She kept the title of Attorney General but reportedly lost access to some internal discussions. Then during the holiday period last year, her name surfaced in a parallel investigation. Not as a target, but close enough to raise concerns. And that's when you start to understand the calculations she might have been making. Inside Washington, there is a pattern that experienced political observers recognize. Loyalty is powerful, while the system protects you. But when legal exposure appears, every individual eventually faces a personal decision. Protect the group, or protect yourself. Bondi had watched previous figures from the president's orbit face legal consequences. Michael Cohen, Rudy Giuliani. Each case carried its own lessons about what happens when loyalty collides with federal prosecution. And according to several people familiar with the situation, Bondi may have decided she wasn't willing to take the same risk. That decision culminated Thursday afternoon when she stepped into that courtroom and began answering questions under oath. At that moment, speculation turned into testimony. And testimony backed by documentation has a way of moving investigations forward much faster than anyone expects. Which is exactly what appears to be happening now behind the closed doors of federal prosecutors. What happened next inside that courtroom is the moment many legal observers believe changed the entire trajectory of the investigation. It was Thursday afternoon. The questioning had already been underway for hours. Lawyers were moving through financial records, contracts, and communication logs piece by piece. Then prosecutors asked Bondi about a specific meeting, not a financial transaction. A meeting. Location. The Oval Office. February 14th, 2025. According to the transcript, Bondi paused before answering. She briefly looked toward her attorney. Then she spoke. She confirmed that she had been present when the president discussed structuring an agreement connected to a development project in Doha. But that alone wasn't the shock. What froze the room was the next sentence. Bondi testified that the discussion included instructions about structuring the deal in a way that would avoid congressional notification requirements. And just like that, the atmosphere inside the courtroom changed. Reporters immediately stopped typing for a second. Defense attorneys stood up almost instantly. Trump's legal counsel requested a sidebar with the judge. Prosecutors asked for a 15-minute recess. 3 journalists rushed out of the courtroom to file breaking updates before the transcript even finished being read aloud. When testimony resumed roughly 23 minutes later, Bondi walked prosecutors through the details step by step. The project in question involved approximately $340 million tied to a development arrangement in Qatar, American partners, foreign financing, multiple layers of corporate entities structured between the investors and the project itself. According to Bondi, the participants were aware of reporting thresholds that would normally trigger congressional review. The structure of the deal, she testified, was designed specifically to remain below those thresholds. Now pause for a second and consider what that means legally. Congressional notification rules exist so lawmakers can review certain foreign financial arrangements involving American interests. They act as an oversight mechanism. If a deal is structured deliberately to avoid that review, investigators begin asking whether the intent was to bypass oversight entirely. And here's where the story became even more explosive. Bondi did not testify that the president acted alone. She named names. 8 individuals present in that discussion. Current officials, former officials, advisors. And according to the public portion of the transcript, one of those names belongs to a sitting member of Congress. Within an hour of that testimony, the judge ordered a portion of the transcript sealed. Reporters had already captured some of the basics, but the detailed list of names and certain descriptions of the meeting were temporarily removed from public access. That kind of sealing usually happens for one reason. Investigators are protecting an active lead, or they are preparing for additional charges. And you could see the ripple effects beginning almost immediately outside the courthouse. By Friday morning, one of the individuals believed to be referenced had already hired a prominent white-collar defense firm in Washington. The announcement came before reporters even had time to formally request comment. Nobody asked him to speak. He volunteered a denial. That alone caught the attention of several legal analysts. When someone hires a major defense attorney within hours of sealed testimony being mentioned, it usually means they already know their name appeared somewhere in the proceedings. Another office connected to the rumored list of names responded with a single-line statement, "No comment." All inquiries directed to legal counsel. Silence like that is often louder than any press conference. And then the judge did something that raised even more eyebrows among observers of federal courts. She scheduled an emergency status hearing for Tuesday, March 10th. That move accelerated the timeline dramatically. Federal investigations often unfold slowly, with months of procedural delays between major hearings. But when a judge orders an emergency session only days after explosive testimony, it signals urgency. Something inside that sealed portion of the transcript appears to have pushed the court toward faster action. Prosecutors followed up almost immediately by requesting expedited discovery orders. They asked for additional financial records, communication logs, and banking data tied to international accounts mentioned during Bondi's testimony. The judge approved those requests within hours. If you're familiar with how federal investigations typically move, that speed stands out. Courts are usually cautious about granting rapid discovery, unless prosecutors demonstrate that time matters. Which raises the obvious question now circulating among legal circles. What exactly is inside those sealed 2.5 hours of testimony? Remember, Bondi remained on the stand for nearly 4 hours. Only about 90 minutes of that testimony has been released publicly so far. The rest is locked behind a temporary seal. Some legal experts believe the sealed portion could include additional financial structures tied to foreign investments. Others suspect it might contain discussions of individuals not yet formally connected to the investigation. And then there is the possibility that prosecutors are protecting cooperating witnesses whose names cannot be revealed yet. Whatever the reason, the secrecy is fueling speculation across Washington. Meanwhile, the political reaction continues to escalate. Within hours of the testimony becoming public, the president responded through a series of posts on social media. In those messages, he described Bondi as unstable, desperate, and disloyal. One post dismissed her understanding of the events entirely, suggesting she had never been intelligent enough to grasp what she witnessed. The reaction spread quickly. Millions of views in less than half a day. Bondi's legal team responded the next morning by requesting additional security protections. When a cooperating witness becomes the center of a political storm, threats and harassment often follow. And this is where things become particularly delicate from a legal standpoint. Prosecutors have already begun referencing public statements from the president in their filings. They argue that repeated attacks against a cooperating witness could be interpreted as attempts to intimidate or influence testimony. Whether that argument holds up in court remains to be seen. But the fact that prosecutors are citing those statements suggests they are paying very close attention to the public messaging surrounding the case. Meanwhile, Republican leadership in Washington appears divided in its response. Some figures quickly defended the president and dismissed the testimony as politically motivated. Others adopted a noticeably cautious tone. One senior Senate Republican reportedly told reporters that lawmakers should wait to see what appears in the sealed documents before making strong declarations. In political language, that kind of statement often signals uncertainty, not support, distance. And while politicians debate the implications, prosecutors continue building their case quietly through documentation. Because behind every dramatic courtroom moment sits something far less theatrical but far more powerful. Financial records, wire transfers, bank confirmations, corporate registrations. Those are the pieces investigators use to build timelines that juries can understand. Bondi's testimony may have opened the door, but what prosecutors find behind that door over the next several days could determine how far this investigation ultimately goes. Now we arrive at the question that matters most. Why should anyone outside Washington care about what happened inside that courtroom? Because the consequences of this kind of investigation do not stay inside legal documents. They ripple outward into politics, markets, policy decisions, and public trust. The moment Bondi finished her testimony, the first shockwaves were already moving through financial markets. Investors watch political stability the same way radar watches storms. And when a potential corruption investigation touches foreign money and government decisions, markets react. On Friday, several defense contractor stocks dipped roughly 2.3% after early reports linked the Qatar development project to companies connected with U.S. defense supply chains. It wasn't a collapse. It was something quieter but still meaningful. Uncertainty. And investors hate uncertainty more than almost anything. If you have retirement funds, pension exposure, or investment portfolios tied to U.S. markets, even indirectly, you are connected to these developments whether you follow politics or not. Large corporations now have compliance teams reviewing contracts and international partnerships just in case any of their business relationships intersect with companies mentioned in the investigation. That kind of quiet corporate review happens long before the public notices. Another consequence sits in the realm of precedent. If a sitting attorney general can eventually testify about internal conversations involving a president, it forces future administrations to reconsider how executive privilege might be interpreted. Every future cabinet member watching this case will be asking themselves a difficult question. If I am told not to document a conversation, should I document it anyway? That single calculation could reshape the internal culture of government for decades. Imagine a corporate employee sitting in a conference room. The chief executive says this meeting should leave no written record. Years later, that employee hands investigators detailed notes from the discussion. That is essentially the scenario now unfolding at the highest level of federal government. And here is another number worth paying attention to. According to the unsealed portion of Bondi's testimony, 23 individuals were referenced directly or indirectly in connection with the deals under investigation. 8 of those individuals were identified by name inside the courtroom. The remaining 15 were referenced by position, title, or role. Prosecutors already know who they are. The public does not. Federal agencies connected to some of those individuals reportedly began issuing legal hold notices late Friday. Those notices instruct employees to preserve all records, emails, and communication logs. Nothing deleted. Nothing altered. Anyone who has worked inside government or major corporations recognizes that signal immediately. Legal holds usually appear when investigators believe documents may soon become evidence. And then we reach the uncomfortable part of this entire situation. If the allegations described in Bondi's testimony are accurate, it means financial arrangements involving foreign investors may have influenced decisions made during the president's second term. Policy priorities, regulatory actions, strategic partnerships. The possibility that undisclosed financial incentives shaped those decisions would raise profound questions about transparency and national interest. Now let's be clear about something. None of this has been proven in court yet. Investigations test allegations. Courts determine guilt. But the documents presented so far suggest that money moved through structures designed to remain difficult to trace. And when large sums of international money intersect with political power, investigators tend to dig very deeply. Across Washington, another calculation is happening quietly in private offices and law firms. If Bondi decided to cooperate, who else might follow? Every person mentioned in the testimony now faces their own legal evaluation. Lawyers are reviewing emails, reviewing financial records, reviewing every conversation that could potentially appear in future subpoenas. The first domino may have fallen Thursday afternoon. But history shows that once one insider begins cooperating, others sometimes decide silence is no longer their safest option. And then there is the response from the president himself. Late Thursday evening, a rapid series of posts appeared online attacking Bondi personally. 11 posts in roughly 3 hours. The language was blunt, dismissive, and highly critical of her credibility. Those messages spread quickly, drawing millions of views overnight. But from a legal perspective, they may carry unintended consequences. Prosecutors have already cited some of the statements in their filings, arguing that public attacks against a cooperating witness could be interpreted as attempts to intimidate testimony. That argument may or may not succeed in court. But it signals that prosecutors are watching not only the courtroom but also the public narrative surrounding the case. Meanwhile, the president's legal team has begun pushing back through formal motions. On Saturday, they filed a request asking the court to exclude portions of Bondi's testimony, claiming certain conversations fall under attorney-client privilege. Prosecutors responded quickly. Their argument is that Bondi was not acting as the president's personal attorney during those discussions. Instead, they say she was present as a government official witnessing events. That distinction will be one of the central legal battles during the next hearing. Which brings us to the dates now circled on every political and legal calendar in Washington. Tuesday, March 10th. The judge will hold a status conference addressing the privilege dispute and potentially reviewing whether additional portions of Bondi's testimony should remain sealed. If the privilege claim fails, more of the transcript could become public very quickly. If the claim succeeds, the investigation slows down while legal arguments continue. Then comes Thursday, March 12th. A federal grand jury is scheduled to reconvene. Prosecutors are expected to present new evidence collected since Bondi's testimony. Grand juries decide whether sufficient evidence exists to pursue indictments. That decision does not guarantee charges, but it marks the moment when investigators believe their case may be strong enough to proceed. There is also another date quietly appearing on the court calendar, March 17th. A tentative slot for the next witness testimony. The identity of that witness has not been disclosed publicly. But if prosecutors are scheduling additional witnesses this quickly, It suggests Bondi may not be the only insider now cooperating. For the moment, however, the public remains in a holding pattern. Here is what we know right now. Pam Bondi has completed her initial testimony and secured immunity. Portions of the transcript are public, while roughly 2.5 hours remain sealed. 8 individuals were named during the hearing, including one sitting member of Congress whose identity has not yet been released. Prosecutors have requested banking records from 4 international financial institutions tied to accounts mentioned during the testimony, and the legal machinery of the federal court system is now moving faster than many observers expected. On the surface, this story may appear simple. A former ally turns against a powerful leader. But beneath that surface sits something more complicated. Bondi did not wake up one morning and decide randomly to cooperate. Something pushed that decision. Perhaps legal exposure of her own. Perhaps evidence prosecutors already possessed. Perhaps conversations we have not yet seen revealed. Whatever the reason, Thursday opened a door that had been closed until now. Behind that door are financial records, international investments, political relationships, and conversations that may reshape how this entire chapter of American politics is remembered. The next answers may arrive Tuesday. And when they do, the scope of this investigation could expand far beyond what anyone imagined just a week ago. So now the question hangs over Washington. Bondi stepped forward. Who steps forward next?